Friends, last week, in fact, last month, on 27th of May 2020, 2026, two important judgment was pronounced. One important judgment was related to the constitutional validity of the term betting and gambling, on which whether the state can make the law or not. And second point was that what is the term betting and gambling for the purpose of GST. These are the few important development that has taken place in the last month. And first, we will discuss about the first judgment, which is the judgment of the Jungli games here. In the Jungli games, the discussion was on the issue of the constitutional validity of the entry number 34 in the state list, which talks about the term betting and gambling here, whether the state has the power to levy the taxes on the betting and gambling. I would like to just to go a bit background of the case here. The background of the case is that there was a law under the Tamil Nadu State Act here. And that law was the 1930 law, which used to levy the tax or used to where the concept of the gambling was there. And under this concept here, the Tamil Nadu government used to regulate the law related to gaming part here. However, in the year 2021, after around 100 years, or you can say that after 91 years, the government, in order to see that earlier the game used to be on the physical form, but now the games are taking place in the online forms. The government made the amendment here. Government made certain amendment, and the purpose of the amendment was because that time when the law came here, in the new law 2021 amendment came, the people were used to get addicted by this online gaming. And the issue was there whether the online gaming is covered under the term, particularly about the betting and gambling. And most important part was that if the online gaming is a game which is online gaming is arising due to the game of skill. So there was a law used to distinguish the game of chance versus game of the skill. Now, what happened subsequently here? The 2021 amendment, which came in the Tamil Nadu Act, that is called the Tamil Nadu 1930 Act, which was the Tamil Nadu Gaming Act 1930. The purpose of the object and region of that amendment was as under. I'm just reading the amendment here. It says, gaming by means of card, dice, etc. in the form of betting and wagering has been banned in the cities of Chennai, Madurai, Coimbatore, Salem, and Tiruchirappalli, and by the Chennai City Police Act. Read with Tamil Nadu 32 of 1987, Tamil Nadu Act 1987, and the rest of the state by Tamil Nadu Gaming Act 1930. However, the playing game like rummy, poker, using computers, mobile phone for the money, and other sticks which are addictive in the nature has developed manifold in the recent times. So government says that the poker games and other games has been developed in the recent times. Subsequently, as a result, innocent people get cheated and incidents of suicides were reported. So the law says that yes, something is happening here. Let's see that how the suicides are taking place. And after that, in order to prevent the incidents of suicide and protect the innocent people from the evils of online game, it has been decided to ban the wagering and betting in cyberspace by suitably amending the relevant enactment here. So therefore, the 1930 Act was amended by the 2021 Act. I'm telling the story of the Tamil Nadu Act here. This act was challenged before the High Court, and High Court says that the term betting and gambling cannot be separated here. This means they said the betting and gambling will always lead to the where you are playing a game of chance. If there is a game of skill, then it cannot be covered under the term betting and gambling. Therefore, if it is a game of skill, it is a fundamental right under 19(1)(g) to do the business of the game of skill, and that I was on the state of Tamil Nadu 1930 Act, which act was Tamil Nadu Act was about the 1930 Gaming Act. After the 91 years, 2021 amendment came, and due to this amendment here, the law was changed. And when the law was changed, it was said that particularly the purpose of the law was that because at the time many people used to play the online game through the poker and like this one's here. The law changed and law says that all type of betting and gambling will be regulated by the state under entry number 34 of the state list. This amendment was challenged before the Tamil Nadu High Court in Madras High Court, and the Madras High Court struck down the amendment. The reason was that Madras High Court relied upon three judgments that we will be discussing in the detailed part here. And Madras High Court has relied upon the three judgment, which said that the game of the skill is an independent of the term betting and gambling. Minded this part here. The game of the skill. So they said that whenever there is a game, game has two components, whether it is a game of skill or it is a game of chance. If it is a game of skill, it is out of the ambit of the betting and gambling. Then the issue will be there. If it is then the state cannot make a law for the purpose of game of skill. They can only make the law for the game of chance. The second proposition was there. The game of skill is a fundamental right of doing the business under Article 19(1)(g), and therefore it is my fundamental right, and no law can infringe the fundamental right. This was the main argument before the Supreme Court, before the Tamil Nadu High Court. And Tamil Nadu High Court, what the Tamil Nadu High Court has done, Tamil Nadu High Court has said that Tamil Nadu struck down this amendment here. And let's see how the Tamil Nadu High Court has struck down. The Tamil Nadu has said that the online gaming company had challenged the constitutional validity of 2021 Tamil Nadu Amendment Act on the ground that it was infringing their fundamental right because about the game of skill. And also because the legislation was manifestly arbitrary as it clubbed together the game of skill and the game of chance, which cannot be segregated because one bucket here. The second point which the High Court says, the High Court felt that the gambling cannot taking a chance and also acknowledged that in the usual sense, there is no distinction between game of skill and chance in order to amount of gambling. The court says there cannot be any difference, and therefore the court says since you have merged both the game of the skill, game of skill and game of chance, it goes to the arbitrary part here, and further the game of skill cannot be controlled. Game of skill cannot be controlled through the article entry number 34 of the state list, and game of skill is my fundamental right, and therefore it is covered under the article 19(1)(g), and the court cannot, or the legislature under the state act cannot control this part. This was the Tamil Nadu position. The same position came to the Karnataka. In the Karnataka also there was a police act here, and after this the amendment was made in order to curb the online gaming. And again, the Karnataka High Court says that there's a distinction between the game of skill and game of chance, and the game of skill is covered under the Article 19(1)(g). It cannot be curbed, and only the game of chance can be covered here, and game of chance is covered under the term betting and gambling here. So therefore, they mainly says betting on gambling, not the betting and gambling. While doing so, they particularly relied upon the three important judgments, which we will discuss in the later course here. The matter reached to the Supreme Court here. The matter first reached to the Supreme Court, and Supreme Court, what the Supreme Court has said. Although there are a lot of argument on the betting and gambling, what is the betting and gambling, how the betting and gambling will take place, what is the right on the betting and gambling, how to understand the betting and gambling, whether the term betting on gambling is there or betting and gambling is there, and what are the distinctions between betting and gambling. There are a lot of argument which has taken place. I'm going slowly into this part here. Then after that, we will come to the game craft judgment here, which is related to the GST. But the foundation is coming from this judgment here. And they have said that online gaming, how to be covered that online gaming part here. Let's see. I'm coming to the three important judgment here, which will be useful for our discussion in the due course of time. Particularly the state was arguing that their law controls not only the game of skill but game of chance here. So they have the valid law. But the gaming association was of the view that this law is a infructuous here because this law cannot be made and the state does not have the power to make the law on that part here. Now, coming to this, there are a lot of argument is there. I'm coming to the specific court findings and what was the issue before the court, how the issue was made before the court here. Issues for consideration. What was the issue for consideration before the court? This is on the jungly.com here. It's a jungly gaming case here. So Supreme Court made the issue. And so what the issue was there, whether the conjunction and betting and gambling, how to read the and, whether the conjunction appearing in the expression betting and gambling in the entry number 34 of the list 2 of the 7th schedule of the Constitution is to be interpreted to mean that the competence of the state legislature extend only to the betting and gambling activities. In other words, betting on games of pure skill was outside the purview of the legislative competence and the state legislature under the said entry. He said the question was framed whether the game of skill can be part of the term betting and gambling or not, and if it can be termed as a betting and gambling, if it cannot be termed here, whether the state can make the law into this part or not here. And after that, they have discussed the various aspects of that part here. Three important judgments which will be discussed, that RMDC 1, RMDC 2, and KR Lakshmanan judgment. These are the three judgments which was used by the Karnataka High Court and Tamil Nadu High Court, both the High Court, to say that the game of skill cannot become within the ambit of the betting and gambling, and therefore the court does not, the legislature does not have the power to control that part here. So the issue was mainly about the first issue, what is the term betting and gambling? The second issue was there, whether the RMDC 1, RMDC 2, and the judgment of the KR Lakshmanan, three judgment here. RMDC 1 is important judgment here. It came from the Bombay here, where the lottery was issued, this was here. And particularly it was about the competition part was there. We will discuss in detail that how the RMDC came before the Supreme Court. RMDC 1, RMDC 2, and the KR Lakshman judgment that will come here. And all the questions were subordinate to this part here. So the main question which was there before the Supreme Court, what is the difference between the game of skill and game of chance? And whether the state has the power to regulate the game of skill also under the entry number 34 of the state list. This is the main crux of this issue. And that on the crux of this issue, the Supreme Court has discussed the part of the entry number 34. The how to entry number 34 has discussed here. There are various issues on the entry number 34 because it's a constitutional interpretation is there, whether it has to be given a narrow interpretation or it has to be given a wide interpretation. Further, they have also discussed the social part here. It has discussed about the public safety part. They have discussed about the public health part. Particularly, they have also discussed the DPSP, Directive Principle of State Policy Act. They have also discussed if it is not covered under that part here, under the entry number 1, they have the public order. Since the state has to maintain the public order, they can very well make the law onto this part here. However, these are the supplementary issues here which has come. But the court conclusion is that the game of skill, the moment a person what is the important part of that in a gaming industry? Important part is that a person bets. When a person is betting for a money, the moment he is betting with a money, is taking the money for an uncertain outcome because he does not know the outcome here. And third part is that most important part is that what he's trying to do, he's trying to get in an anticipation that he will get much higher value than what he has invested. So there are three part here. Whenever their games takes place here, first of all, there is taking of money. Once he stakes the money, वो पैसा लगाता है. पहला he is taking of the money. Second, the outcome of this money, outcome of this game is totally uncertain, whether he will win or he will lose. So totally uncertain. And third, anticipation. In an anticipation that he will win a higher amount. This anticipation, when he is all the three is clubbed here, then underlying event, whether it is a game of skill or game of chance, is totally immaterial and it will be covered under the term betting and gambling. So for the purpose of betting and gambling, three important things is there. First, there should be some staking of money by the person who is betting here. So first is part of the staking of the money. Second part is that the staking of money is for an uncertain outcome. Outcome is you don't know what will happen in the second part. Third, third part most important, in an anticipation of a higher amount. When the in anticipation is higher amount, all these three element when is there, then whether it is a game of skill or game of chance, it is immaterial and it will cover under the term betting and gambling. This is the crux of the judgment into the constitutional law that is there. This means for the purpose, the moment there is a betting, the moment there is a staking of the money, whether this staking is for the game of skill or game of chance, the law says there is no distinction between that part here. I'm not going to make a distinction whether it is a game of lottery or whether it is a game of chance or game of skill. The moment you have taken a risk, there is a risk element. What is the risk element? First of all, a person has betting some amount. Second, he has done with an uncertain outcome. Outcome is totally uncertain. And the third part is that most important that he is done for an anticipation of the higher amount that he will bet. Suppose that a person starts a betting and he says that yes, I will bet for 100 rupees. Four-person are playing here. Four-person say that yes, I will bet 100 rupees, 100 rupees, 100 rupees, and 100 rupees. Each person has the anticipation that I will get some higher amount after when I will win. When you say that I have sent the I have just I have the moment I have put the money of 100 rupees, it is beyond my control. And most problem is I do not know the outcome. Outcome is totally uncertain. Outcome is totally beyond my control. These are the element is when there is an element of uncertainty, uncontrollability is there. Whether it is a game of skill or game of chance, it will become under the term betting and gambling. So, for the purpose of betting and gambling, the court has said it cannot be a parameter saying that it is a game of skill does not take away or does not take away that it is not a betting and gambling. Only thing is that if it is a game of skill, the risk element is bit lower, but it does not say the risk element is not a parameter to determine here. What is the important is that you staked your money for an uncertain event, uncertain outcome. The moment there is a staking of the money for an uncertain outcome with an anticipation to get some higher amount, this leads to the betting and gambling, whether it is a game of skill or whether it is a game of chance. No at all, no issues here. Underlying event can be there here. Underlying event can be game of skill. a game of chance here. So these are the important outcome of this judgment. Although this judgment is a 200 pages judgment, 262 pages judgment is there, but I'm trying to read the 269-page judgment is there, but I'm trying to read the relevant para, which is very much important to understand, and particularly how this law has unfolded here. How the word, particularly the court has analyzed the word on and on how to understand the difference between and and on. Particularly, I'm reading the para number 226. It says that if the word and mentioned in all this entry are to be read as on by adopting a interpretive approach, this approach will be a wrong approach here. After this court has relied upon the various judgment, I'm not going into this part here. I'm going to the operative part of the judgment here. Let's see what is the operative part of the judgment it talks about. And the court has discussed this issue on the social issue, on the human issue, because the court has said that due to online gaming, the addiction has come, and this addiction is damaging the whole public health, public life, and that part here. I'm reading the relevant para here, which the outcome conclusion is there. In lieu of the aforesaid discussion, we summarize as he says that the High Court of Karnataka and High Court of Madras and High Court of Karnataka committed a egregious error, giving very narrow interpretive of the entry number 34 of the list 2. Both the High Courts failed to take into account the power intended to bestow upon the state legislature under the said entry of the framer of the Constitution. This has rendered the state powerless to prohibit the activity of betting and gambling. The first part they are saying. Second part that they are saying, the natural corollary of the observation made the court is RMDC2, which are there, that if the game is of substantial skill are conducted in the manner that they start to pose a severe threat and problem to the state or cause harm to the public, then the state will not be powerless to regulate such game in of a substantial skill as well. In the present case, since the betting and gambling of betting on games of skill is posing a serious threat to the state and the well-being of the masses, such betting would not enjoy immunity merely because it is taking place in the name of game of skill. Simply saying that it is by giving the name of the skill, it does not immune from the legal from the state to make the law. There was no occasion for the court in the case of the this one, RMD1 and RMD2. The court earlier, this judgment of the Supreme Court on which the Madras has relied and the Tamil Nadu has, Karnataka had relied, they said that in both the judgment, there was no occasion to discuss the scope of the term betting and gambling. They were discussing something else. So what the court is saying, there was no occasion for this court to consider the scope of the term betting and gambling as it appears on the expression betting and gambling in the entry number 34 of the list 2, and also the nature of conjectures and joining the two words on the RMDC 1 and RMDC 2. Fourth part is that while it may be true that the games of skill may not get covered under the gambling, it is not correct to say that betting on games of skill would be out of the competence of the listener. He says that what is important part is that while it may be true that game of skill may not covered under the term expression gambling, it is not correct to say that the even betting on the game of skill would be out of the competence of the state legislature. So what is trying to say that if the game of skill is not covered under the gambling, it is definitely covered under the term betting because you have put the money, you have staked the money into this part here. So therefore, it is covered under the term stake of money. Fourth, the K.R. Lakshman cases, the scope of expression betting and gambling as appearing in the entry number 34 was not a subject matter of determination. In the K.R. Lakshman case, which the Tamil Nadu High Court and the Karnataka High Court had relied, the court says In the Lakshmanan case, there was no occasion to discuss the scope of the betting and gambling, and it was not a matter of determination. Rather, the issue pertained whether the horse racing would be entitled to the protection of the execution that the state legislature had itself carved out in the name of mere skill under 49 of the 1963 Police Act under Section 11. So it was only for the purpose of protection of the horse race here. KR, this one, the judgment of the KR Lakshmanan case here. So it was not the case where the court has discussed the term betting and gambling. Further, the the court in the K.R. Lakshman case has no application of the case as one of the hand the state legislature and its wisdom has deemed it appropriate to regulate games under the monetary stakes are where the monetary stakes are involved without affording any special protection to the game of skill. So with this, the court has said, particularly in the last para, the quote I is very important. Let me read this para G also. The reading of the reading of the decision of the K.R. Lakshmanan case also indicates the court therein considered the manner in which the club operated and conducted the horse race as well as the process in which the wagering and betting happened. The observation of the court clearly indicated that the entire process of conducting races and betting on them was highly regulated and organized, which is very different from the uncertainty and will of invisibility associated. Important part is that the finding of the impugned judgment that the expression betting and gambling ought to be interpreted as betting on gambling is a clear constitutional aberration, tinkering with the constitution of actually rewriting the constitutional text. One more important part, the constitution, the betting and gambling cannot be split. So the term betting and gambling, just like we read the pipes and tubes. So pipes and tube are incidental to each other. So the term betting and gambling cannot be removed here. It says the expression betting and gambling cannot be split to mean that the staking angle alone would be amount to betting, whereas the risk angle or the chance element would amount to gambling. Both betting and gambling involve the aspect of staking money on an uncertainty. Merely because the risk element is commonly perceived as taking chance, it cannot mean that the expression would cover only game of chance. The protection afforded to the game of skill under entry number 34 cannot be construed as a protection of betting on games of skill and certain and essentially becomes the gambling enterprises here. So why this says that game of the term betting and gambling is not confined to the game of chance. It includes the game of skill also. And since it includes the game of skill, the state has the power to regulate, to manage, uh, and to develop the law on account of on the issue of the betting and gambling. These are the important. Although it is a constitutional judgment here, this judgment is not related to GST. GST, when we'll come discuss here, which is the next judgment, which talks about the gamecraft judgment. However, the gamecraft judgment will start from this judgment here, because in the gamecraft, the court starts saying that in the jungly game here, I have already decided that the betting and gambling, whether it is a game of skill or game of chance, is already covered under the term betting and gamblings. In the case of the in the case of the gamecraft, which will start from the term betting and gambling. So if we can see that in the judgment of the gamecraft, the court starts saying that I have just decided the case of the jungly games here, where we have held that the term betting and gambling includes the game of skill, and state has the power to make the law into this part here. However, the game craft will start a different line here. It will start from different line. The argument will be there in the game craft saying that whether the game, how the game will be subject to GST. The purpose of the game craft is to say that how the online gaming, how the online betting will be subject to the GST. So the crux of the issue will be there, whether the term betting and gambling amounts to an actionable claim or not. Unless if it becomes an actionable claim, and how it becomes the actionable claim, we will discuss in the game craft judgment. And we will discuss that how the actionable claim, whether the actionable claim is covered under the new law or not, GST law or not. What was the position in the Sales of Goods Act? What was the position under the VAT Act? What was the position under the Service Tax Act? Whether the actionable claim was subject to tax or not. If the actionable claim is subject to tax under new law, then what is the new law talks about? We will discuss about the Mohit mineral matters also into the game craft judgment. And we will go into a bit detail also that how to understand that part here. One more important things that will be coming into this part is the wagering agreement under section 30 of the Indian Contract Act. How to understand the wagering agreement, whether there is a wagering agreement between the person who is playing like portal, like poker game, like someone like a cricket 11 or make my team.com, where you can play with the you can choose your player to make that part here. How to understand this part? This all will be coming into this issue. However, before going into this part, I will like to just ask if any one of the my here has some question on the issue of the jungly.com here or jungly game, so I can explain that question here on the jungly here. Anyone has some question on the jungly? If there is no question, then I will move to the game craft judgment. Any question on the jungly? I feel that I have received some of the questions on the jungly. Just hold on. Some question was raised through the some chat here. It says that the court has rejected the interpretation betting and gambling should be read as betting and on gambling. How significant is the finding from the perspective of constitutional interpretation and the legislative competence here? Very much important question is that. The question is that how the court has distinguished between betting on gambling and betting and gambling. As I have discussed right now, the court has said the entity is under the entity number 34. The term is betting and gambling. Each term has to be given its proper meaning. You cannot read which is not written under the constitution. So betting and gambling means there is a betting and there is a gambling. Yes, both has some different interpretation here. Both has the different interpretation and both are connected to each other. Like as I discussed here in the conclusive part here, the game of skill, which is the core issue of the dispute is there. If the game of skill, if some stake is there, money stake is there, and due to some money stake for an uncertain outcome is there, yes, risk may be lower into this part. But the moment some money has been staked into this part, there is an uncertain outcome is there. It will lead to the betting. And court has said that it may happen that since you have the skill set here, so you can say that I'm not playing gambling, but it is betting here. Why betting? Because you have staked the money into this part here. You have just staked the money for an uncertain outcome. You have staked the money with an anticipation to have some more amount into this part. to in the return that you want more amount that part here. So therefore, the court is saying that it is a case where you need where you have staked the money, and therefore it is covered under the term betting and gambling, not the betting on gambling. Why? Because in the Madras High Court, they have interpreted betting on gambling. This means they were saying that it is only with the relation to the game of chance, game of skill cannot be part of the betting on gambling here. The law says, Supreme Court says, no, 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 it is betting and gambling. And even if it is a game of skill or game of chance, the moment you have staked the money, so it is not important whether the underlying game is the game of skill or the underlying game is the game of chance. What is important is taking of the money. What is important is taking of the money for an anticipation, for an uncertain outcome. What is important? You have staked the money for an uncertain outcome with an anticipation to get some higher amount. So therefore, this term that has to be considered for the purpose of understanding the law, and the court has said, yes, this is the betting and gambling, not the betting on gambling. One
Sir,
more
there is a
question that
question.
yeah, please, please.
Yes, sir, there is a question in chat box, sir.
Chat box here.
Sir, she
Oh,
has
how
said,
would
how
you?
would we counter their article 19(1)(g) argument?
Yes, as I mentioned that it was the issue which was raised before the High Court of Madras and High Court of Karnataka. They have the Association of Game has raised the issue that game of skill is out of the ambit of the betting and gambling, and game of the skill is covered as my fundamental right. It is a legal right. It is my fundamental right, which should not be infringed. And it is covered under my 91G. 91G talks about right of doing any business and profession. Subject to the any law, you can very well do any business and profession. So the element was that this says that if it is a game of skill, the game of skill is not covered under the term betting and gambling. It has to be covered under the Article 19(1)(g), and game of skill is not cannot be regulated by the state. Even the game of skill cannot be regulated by the union also, because it is my fundamental right. However, when this matter came before the Supreme Court says that it is not issue important that whether it is a game of skill or game of chance. What is important for the purpose of betting and gambling? It is the staking of the money for an uncertain event in an anticipation to get the higher amount here. Underlying event can be the game of skill or game of chance, and therefore the Supreme Court has negated the argument of 19(1)(g), saying that 19(1)(g) has no role here. All the betting and gambling is covered under the term betting and gambling, which is Indian number 34, and the state has the power to make the law relating to the state, relating to the betting and gambling. The court has tried to, not only court has discussed the literal interpretation, in fact, anti-interpretation of the term betting and gambling. Court has looked this scope in a different perspective. How the different perspective, as I said that, court has said it is a case of the public health. Court has said it is a case of the public order. Court has said it is the case of the public safety. Court has said it is not only about the terminology, but I'm trying to say that what should be the order here. If I read that particularly part here, just hold on. Very important judgment is there. Court has said that under that directive principle, under Article 30, what is the directive principle? Start from the sorry, it starts from the Article 38 of the Constitution here. And under the Article 38 here, it starts from the DPSP. The power is there for the state to make the law which is for the good or for the betterment of the society, betterment of the people. And this type of online gaming, when it is causing harm to the public, when it is causing it is causing suicide to the public. People are taking the loan and they are addicted. It is just like a drug addicts here. People are playing the games in such a manner so that whether it can be it is a harm to the people, that the state has the power to make the law. So the court has looked this gaming, on betting and gambling from a totally different perspective, in a very holistic perspective, not only from the constitutional perspective here. Hope I have replied this part here. Anything,
Sir, there
anything
is a
next?
question
Yeah, please. Just
in the
hold
chat
on.
box, sir.
I can. Yeah, yeah. Do you agree with the Supreme Court view that once stakes are introduced, the distinction between the games of skill and the games of chance become largely irrelevant for the purpose of entry 34? As you have rightly raised, once the money is staked into this part and the outcome is totally uncertain, it is beyond your control. The person who is playing does not know or do not know whether he will win or he will lose. If even though it is related to skill, he can have something in anticipation, but it does not take away. It indeed does not take away the uncertainty of the event. It may happen, the uncertainty may be lower this side or that side here. Like suppose that you are betting some person who is a well-tested one. So you can say that yes, he will win. Okay, by way of experience, he can say that. But it does not say only part that your risk element will be lower, but the outcome is totally uncertain. When the outcome is totally uncertain, you do not know whether this will or that will happen, and also you have done for the purpose of getting some higher amount into this part, then the issue of the game of skill, underlying issue of the game of skill and the game of chance get vanished here. It is nothing, it is totally irrelevant here. And in law says the moment you have betted, the moment you have betted for an uncertain event, the moment you are betted for the purpose of outcome, because some extra amount, which that then the amount that you have betted with an anticipation to get higher amount, all this will lead to the betting. Underlying event can be it can be your chance, it can be your chance, it can be your skill, that both can be there, or therefore that does not make any difference into this part here. Hope I have replied this part here. Any more question? Then I will switch over to the gamecraft.
Yes, sir.
How will it shape Indian gaming jurisprudence in the coming decade?
Yes, sir.
Yes, very, very good question that has been raised here. Now you can say that one more thing, very, very important part is that now the betting and gambling can be controlled by the state here for the purpose of making the law onto this part. So therefore, the law, see the police, they can make some stringent law into this part. They can control on that part. They can regulate the law. They can do some police action. They can say that if this law will not be complied, there can be some prosecutions, or they can also discuss some imprisonment. They can also discuss. They can also make it fine also. So it can be looked into whether the state wants to make it a criminal law. They want to say that yes, if you have violated the provisions of the betting and gambling, then it will be a criminal offense to you. So the legislature, by way of doing something, they can also create an offense. If it is an offense, they can also go for the purpose of imprisonment for certain period here. Like under this Tamil Nadu Act here, they have created that yes, there will be imprisonment also. If I can read this part, Tamil Nadu Act was, just hold on. What was the effect of the amendment in Tamil Nadu and Karnataka? You see that the amendment, what was the effect and why this gaming company went to the court here. I will just read the effect of the amendment here. Section 3, Section 3A was introduced in the Tamil Nadu Act. The Tamil Nadu Act was 1930 Act here, Gaming Act, and this act was introduced here. And what is the effect of this amendment? I will just reading. I'm just reading the law. No person shall wager or bet in cyberspace using computer system, computer network, computer resource, any communication device or other instrument of gaming by playing rummy, poker, or any other game to facilitate or organize any such wager wager in bit in cyberspace. Then comes to subsection 2, 3A subsection 2. Whoever wagers, whoever wager or bet in cyberspace using computer system, computer network, computer resource, any computation, any computation devices or any other instrument of gaming by playing rummy, poker, or any other game or facilitate or organize such wager or bet in cyberspace shall be punished. So it was made a criminal law, shall be punished with an imprisonment which may extend to 2 years with fine not exceeding 10,000 rupees or both. So the law was made saying that it is a criminal offense. You will be imprisonment under the imprisonment. Yes, imprisonment was for the purpose up to 2 years. So it was a bailable offense here. So you can get the bail of that offense here. Imprisonment was for the 2 years. So the law was made into the Tamil Nadu Act. Similarly, there was a Karnataka Act where the same type of law was made. So with this, when the court has upheld the power of the state to make the law on the issue of betting and gambling, now all this amendment is become valid. Earlier, the court has just struck down, that has been set aside. All this amendment has become valid, and this law will prevail. And therefore, all the states, because it is the state subject here, all the states can make the law. Now you will see many states here, like many states will making the law, particularly about the uh, social media issues like online gaming. In fact, today, as on today, every mobile is a gaming instrument here. Every mobile, there is a gaming part here. The court has discussed this issue that now you don't need any computer. In every person hand, whoever is using the smartphone are playing the online games. If that is the so here, and the effect of this is so much here that people are getting addicted. I have seen many people who are addicted to this online gaming. Like when the cricket match will come, they will be making the team. When there will be many cases when they will be doing into this part, and people are addicted. This is the bad addiction. In fact, people are addicted to the mobile phones here. So the effect is very severe here. Yes. Anything more that you would like to ask?
Sir, there is one more question.
Yes, I will read it. Sir, can this judgment be regarded as the expanding the legislative power of the state in regulating emerging digital services such as online gaming and fantasy sports? This is not that case that it is expanding. It is just a clarifying. In fact, the legislative has the power to regulate all this type of gaming. Legislative had already power. Only the confusion which was raised that if it is a game of skill, the legislature cannot regulate here. But now the Supreme Court has come saying that nothing doing, even though it is a game of skill or game of chance, you have stake the money. The moment it is a betting, stake the money for an uncertain outcome, it will lead to the betting and gambling. So therefore, it will be covered. The state will control this part. State will be have the right to regulate all these things here. Any question here?
No, sir, there is no question. Now we can move ahead.
Okay. Now come to the game craft judgment. I understand that many people here who are from the tax background, they will like to listen on the game craft here. I will like to say one part here. The game craft judgment starts at a point where this judgment finishes here. So therefore, to understand this judgment was very much important. Let's see about the game craft here. In game craft, the issue was that here there were so-called notice was issued by the GST department, and many of the gaming company who were playing the games to the others here, they were in initial period they were not paying the GST. When the so-called notice was issued to them, they started the paying of the GST, particularly on the amount which they used to retain, not on the full betting amount here. And they said that my commission, my earning is only this much here. So I on that part, I'm paying the GST. So when the so-called notice was issued to many of the company, even in the case of Gamecraft here, the so-called notice was around 21,500 crores. Big amount of GST was notice was issued. Every company or every SSC rushed to the High Court here for getting the stay. And in some cases, they got the stay here. And after that, some cases say that it is a game of skill, and the game of skill is not covered under the term betting and gambling. And therefore, it is the GST cannot be levied into this part here. But all this matter was transferred to the Supreme Court, and Supreme Court has passed a very consolidated order. The first argument was that before the Supreme Court by the ASG. What was that? As far as the game of skill or game of chance, there cannot be any distinction between the game of skill and game of chance, because it is, we are not trying to say that we are not trying to tax the game of skill or game of chance. We are trying to tax the betting part. What is the betting? When you put the stake the money into that part here for an uncertain outcome, for an for an amount which is higher than the amount, then only it becomes an betting. And for the purpose of betting, then I'm going to tax it here. First part was there. So first part which is following from the jungly.com, jungly judgment here. The second part, which is the most important part, is that say that the betting and gambling, particularly for the purpose of GST, is amounts to an actionable claim. How it takes amount to, it gives a right when a person, suppose that a person stakes 1,000 rupees, there are 4%, and 4% has staked 1,000 rupees each. The moment a person has staked 1,000 rupees each for an uncertain outcome, because nobody knows this one's here, uncertain outcome, and someone will win, only one will win here, or only this one's here, and suppose that he wins here, and he gives 3,600, the 400 rupees that is the commission of the online portal here. Then what is happening? He has a betting his amount of 1,000 rupees. The moment he is betting of 1,000 rupees, what he is getting? He is getting a right to claim, right to claim. Only this right to claim is there, but it may be the conditional when he will win. But right to claim, as on the moment he has staked the money, he has got the right to claim. And this right to claim is covered under the section 3 of the Transfer of Property Act, and this right to claim is an actionable claim. It can be it can be taken. The person after winning, he can go for the actionable perm, he can file the suit for the getting the money. So actionable claim that he arised here. Most important part is that if it is an actionable claim, how to understand the term actionable claim, how to value the actionable claim, who is the supplier of the actionable claim, what is the point of supply of the actionable claim, how to do the valuation part of that part. Very, very much important. And most important part, whether the actionable claim is a goods or services. These are the very important issue. And what will happen if the goods was not there? If that actionable claim is not a goods, how to understand this part here? Before this, to discuss the actionable claim, I would like to discuss about few of the important part here into the law. What the actionable claim says here, when there was a prior to GST, there was a law called Service Tax, Sales of Goods Act, or under the VAT Act. Like betting and gambling was covered under the state list here. So only the state was empowered to tax the betting and gambling. So therefore, prior to that part here, prior to coming into the GST net, it was taxed as a luxury tax, or you can say luxury tax on the hotel and betting and gamblings. And there was a tax that was levied by the state. Union has no power to tax it here. Similarly, under the sales tax scheme here, it was treated as the betting and gambling. It was treated as the services part here. In the service tax, if you can see under the service tax was the tax levied by the union. Since the betting and gambling was covered under the state list, union was not empowered to tax the service tax into this part. In fact, it was part of the negative list also under section 66D of the erstwhile service tax, when it says that after the positive list in 2012, the negative list concept came here. Since 2012 to 2017, negative list concept was there. And under the negative list 66D, it was the betting and gambling was covered under the negative list. Means the central government under the service tax had no power to levy the GS tax, service tax on the betting and gambling. Why? It was covered under the state list here. However, the law changed. Law changed in prior to this part here. What was there into the constitutional framework? We had the Article 246, and Article 246 gave the power to the state, union, and the concurrent list also. List one, union list, state list, and concurrent list. NT number 34, which talks about that, was it was covered under the state list here, and state had the power. But when we came to the GST regime, Article 246 has no relevance. Article 246A came into, and Article 246A says they will be levy the GST on the goods and services here. The goods was defined under the Article 366(12)A. Earlier was Article 366(12). Now it came to the Article 36(12)A, and where they says that goods goods means goods includes all mobile object, including including the actionable claim. So it was the definition that came from the constitution part here. When it came, when this definition was adopted to the GST regime under section 2 of the GST, what they say is that goods means all movable property, excluding the securities and money. Money was out, securities were out, but including the actionable claim. So the first point was there, goods was treated as an actionable claim. This is the one of the important part that we have to understand here. So two things here. Whether how the betting and gambling will become an actionable claim, it is a classic discussion on this part here. how this will become a betting and gambling will become an actionable claim. Once it become an actionable claim, then it will become a goods. Once it becomes a goods here, then we will see who is the supplier of the goods, who is the receiver of the goods. If that point is there, then we will see what is the consideration that was involved. Whether the consideration was for the person, whether this supply of the goods was for the purpose of furtherance of the business or not. If it is a furtherance of the business, then it will come into the GST net and based on the consideration. So we have to discuss on the consideration part. Then we will say whether there is a section 15 that will apply or under section 15, which talks about the transactional value. Is there any some rule which has been given? So we will see that rule 31A, 31B, and 31C is there. But this rule has come later after I feel that in 2023. What will happen to the prior to this rule here? And what will happen, whether what should be the GST part here? Because in some portion of time, when the law has started, GST law has started from 1st April 2017 to somewhat in the up to January 2018 for around 6 months, it will levied only for 18%. But after 18, it will be levied at 28% here. So there is a understanding of that part. We should understand how this law will go into this part here. So let's discuss about the GST part of the betting and gambling, which is quite important for the purpose of our discussion and understand of the whole topic here. And for this purpose, I'm trying to read some of the issues here, what this says here, and how the revenue has argued this matter before the court here. Let's see. First argument was there. He says at the outset is submitted that gambling necessarily arises whenever stakes are involved, irrespective of whether the underlying game is one of skill or game of chance. The moment you have a stake the money, it is the gambling starts here. While the game of skill per se may amount to gambling, the introduction of the stakes transform the activity into gambling. So very much important. You can very well say that yes, game of skill may not be per se as the gambling, but the moment you have staked the money into this part, it is a stake of the gambling. Equally, the game of chance involving consideration or a competition fees would also constitute gambling. Where particularly when a game of chance is there, so suppose the game of chance you have putting some entry fees. Even though entry fees will be subject to the betting and gambling, and also some activity amount that you have staked, amount that you have staked, that will also be amount to the betting and gambling. Second part says that, second argument says that in some state, the game of skill was not liable to be punishable under the penal law. The court say the argument is that for the purpose of GST, whether this law is a penal law or not penal law, I have nothing to do with this part here. Like game of skill may be allowed under some of the state, saying that yes, you can do the game of skill. And game of chance, you cannot do it here. Like we have said this article, we have seen that section 3A of the Tamil Nadu Act, which says that if you will do this game of chance here, you will be imprisonment for the purpose of a game of skill that you will do, you will be imprisonment here. The GST department says, I have nothing to do with this criminal part of this one. That the moment there is a betting and gambling, and it has satisfied the three characteristic test, this means you have staked the money. This means you have staked the money for an uncertain outcome. You have staked for in an anticipation of a higher amount, higher return. It will be subject to tax. He's saying that I have the power to tax it here. So I have nothing to do with the criminality or the non-criminality of this law. Third point that they is saying that underlying game, whether the underlying game is the game of skill or game of chance, the participant ultimately wager upon an uncertain outcome over which he has no absolute control. Reliance is placed on the section 30 of the wagering agreement here, how the wagering law is there. And the court says that once you are into the uncertain event, it will, whether it is a skill or chance, then it will be covered under the betting and gambling. Further says that the expression betting and gambling, so it is the betting and gambling and it is not the betting on gambling. And we have seen that it has been decided in the jungly here. Also, what was the argument? Fourth argument is that gaming in ordinary means including playing any games, whether or chance, skill or chance, for stakes where the game is strictly defined. The strictly definition governs the decisive element, most important part, law says, the decisive element constituting betting and gambling is the existing of the stake and not the nature of the underlying game. So existing of the stake is important and not the underlying game, which is important. And you have the statutory immunity from playing the game of skill does not take away my right to levy the GST on such of the games here. Then law also says whether it is a rummy, whether it is a poker, you can say that rummy and poker are the game of skill. But as far as the GST is concerned, I have nothing to do with this part here. I, levy the tax on the betting and gambling. So department is not concerned whether rummy is a game of skill or a game of chance. The relevant consideration is that when any game, including a game of skill, is played with stakes, the operator supplies an actionable claim in the form of chance to win, thereby attaining. So the law is now going into the second stage. Law says the moment you have staked the money, what the what the operator has done, operator has supplied you. What did they supply you? An actionable claim. What is the actionable claim? That it chances to win. The moment you the moment you have participated, the moment you have action into this part, you have got a right, you have got actionable claim. And what is this actionable claim? A chance into win. And when this chance to win is there, it is amount to an actionable claim. Further, one more important part is that the argument is that when the supplier of the actionable claim and the service provider facilitating betting and gambling transaction, what they're saying that once the game of skill is played with stakes, the activity falls outside the entry number 6 of the Schedule 3 of the GST Act. Let's see what the entry number 6 of the Schedule 3 is there. Let's see what is the, just hold on. Entry number 3, Schedule 6. Activity or transaction which shall be treated neither as supply of goods or supply of services. There is an Schedule 3 which says that activity or transaction which shall be treated neither as goods or supply or neither as goods or supply of services. And entry number 6 is there, actionable claim other than the specified actionable claim. The law says actionable claim will not be treated as the entry in the goods, as it treated as the supply of goods or services. But it is not about the actionable claim where the money has been staked here. So we have to make a distinction between which type of actionable claim, which are covered here, which are not to be subject to which will not be covered as the supply of goods or supply of services. Means thereby, the argument which is being taken by the department is that once a betting and gambling is converted into an actionable claim, it is subject to GST and it will not be protected by the Schedule 3. But what the Schedule 3 says here, Schedule 3 says actionable claim other than the specified actionable claim. So the law has said that yes, actionable claim will not be treated as the supply of goods or supply of services, but other than the specified claim. So what are the other than specified actionable claim? Let's see. And when this law has come here, actionable claim is that it has come from the 18th of August 2023. 18th of August 2023, there was some amendment was made, and therefore let's see about the specified actionable claim. And we will see that the specified actionable claim, which is under section specified actionable claim means actionable claim involved or by way of betting, casino, gambling, horse race, lottery, online money gaming. These are the six here, 2102, which was inserted uh, from the 29th of September 2023 by notification number 18 August 2023. Notification number was there 48 of 2003, and through the specified actionable claim was said, and from the Schedule 3 actionable claim other than the specified actionable claim. So the specified actionable claim was subject to tax, and this is saying that Betino, because the betting, casinos, gambling, horse race, lottery, online betting games are subject to tax here. So the third part, which the court is trying to say, the argument is that the moment you have betted into this part, it makes an actionable claim, and when it is actionable claim, it is out of the argument is that it is out of the entry number 3, because out of the Schedule 3 entry number 6, but actually the Schedule 3 entry number Schedule 3 entry number 6 protects the SSC, but not in the case of the lottery, betting, and online gaming. Our main issue is that online gaming. So the online gaming is not protected by the Schedule 3. So therefore, it will be subject to GST. Then the fourth part is that what will be the value of the GST? How to this part here? The argument is that it will be the full value of the stake which has been done here. So the full value means it is the moment a person has staked 1,000 rupees. So on the 1,000 rupees, the service tax, the GST has to be applied. It is not the case that whatever the money that has been returned to this part here. So it is the full value, and for this purpose, rule 31A, 31B, and 31C was there. And this rule was especially to cover this type of transaction. We will see that how this part here. So particularly what the revenue had argued, revenue has in a nutshell, revenue has argued there is no gambling if no stakes are involved. Yes, if there is no gambling, irrespective of whether the underlying game is the game of skill or game of chance. As per the GST law is concerned, since consideration is essential ingredients for the levy. Second argument, there is a gambling once the stakes are involved, irrespective of whether the underlying game is the game of skill and game of chance. Third, the game of chance involving even a competition fees is a gambling. Most important, even a competition fees is a gambling. The game of skill per se is not a game of gambling. The game of skill, when played with the stakes, makes it gambling. So there are few arguments which has been taken by the department in the in this case. And after this, I'm coming directly to the judgment part here, which the court has decided. And the court has decided in a very different way here. Let's see what the court has decided. Court has first decided first part. The court itself says that I have just now in the case of Jangli, I have decided the matter about the applicability of the law on the betting and gambling, historical, constitutional, societal dimension, that I have included that part. And I have this is covered under the state has the power to make the law. Second part of the law is saying that even though it is a game of skill or game of chance. The moment there is a betting, it is covered under the, it is taxable, it is covered into the betting and gambling. Third part, which is there, which is from where the litigation on the GST arises here, that how it is an actionable claim for the purpose of levy of the GST. This is the most important part in the case of GST here. And some part they have discussed about the constitutional validity of the impugned levy on the betting and gambling. So some part is about the constitutional validity, as we have discussed the negative list and positive list and the amendment into the GST. And we can see that the definition of the goods here, if you can see the definition of the goods under the GST law, G. G goods means every kind of movable property other than money and security, but include actionable claim. So the actionable claim is already included here. And what is the actionable claim, which has been defined under? Actionable claim shall have the meaning as assigned to it under Section 3 of the Transfer of Property Act of this one here. So under Section 3, they have defined the Transfer of Property Act. So they are saying that it is actionable claim is a goods. Actionable claim has been defined under the goods. There is no claim, there is no part that actionable claim is not a goods here. One important part that now they have said that there are many judgment, many arguments on this point here. I'm not going into this part here. And betting and gambling is then after that law is discussing the statutory scheme under the GST Act. Then they have discussed about the what is the statutory actionable claim, goods and supply into this part. And it is covered under the term goods here. How it is covered under the term supply, the most important part, how we understand the supply. When it is supply, where the time of supply. The law has discussed that the moment there is a staking of the money, there is a constructive supply of the actionable claim. What is the constructive supply? Because the moment he has got the operator has supplied the actionable claim. So what is the definition of supply? Supply definition under Section 7 of the GST law. If you see that part here, for the purpose of this act, the expression supply includes. So supply includes all form of supply, or the services or both, such as sales. So it does not exhaustive, it does not give an exhaustive definition of supply. It says that all form of supply of the goods or services or both, such as sale, transfer, barter, exchange, blah, blah, blah. So this supply, whether constructive supply of the actionable claim is also a supply, we should not read the law in an unorthodox way. In an orthodox way, if we try to understand when it is a constructive supply by the operator in favor of the player, the moment they is there, there is a supply of actionable claim is there. So the law has discussed that it is the all form of supply, particularly para 15.16. They have discussed that this is the supply. There is a constructive supply that takes place by the operator to the buyer. And once there is a constructive supply, then it becomes a supply of the actionable claim. Nature of supply. Then the issue arises here. What is the nature of supply? The law have discussed the scope that whether the nature of supply is services or nature of supply is goods. However, the law has concluded that it is in goods here. Then the third part is that arises here about the consideration, valuation, and measure of levy. We know that Section 15, where how to section the taxable supply, the value of taxable supply, Section 15 talks about. And Section 15, they have done it. The value of the betting, the moment you bet, the full value it will be covered for the purpose of taxable supply. And there's a detailed judgment on this part here. They have also discussed about the characterization of the online gaming, the characterization of the online gaming, whether it's an online gaming is a services or it is a sub goods here, the court has ultimately find that it is covered under the goods because it is an actionable claim and it is covered under the goods because some of the part of the OIDR law, they have covered the services, online gaming, they have also covered under the services. But the court has said this was particularly for the purpose of OIDR matter, not for the other matters. But when there is other matters, it will be covered into the goods here. After that, the issue was raised there how the validity of the rule 31, validity 31A, 31B, and 31C, because these all the rule came after this after 17 here. Let's see what is the rule here. Just hold on. Thirty-one A came with effect from 23rd of January 2018. 31B came with effect from two that is there, two that it also came from 1st of October 2003, and 31C came from the part here. 31C was came later on here. So both this 31B, 31C is came after 17 here. The issue was arised, what will happen from 1st July 2017 when the law has come here to the date when the law 31A, 31B, 31C has come here. So they have said that they have applied the law of retrospectivity because it is a delegated legislation. They have applied the law of retrospectivity to hold that this provision will apply with the back date here from the date of the 1st of 2017 because it is a part of the section 15 itself. Section 15 is the mother section for the valuation part here. So this rule is coming from the section 15. It will go back to the section 15 and therefore the section 15 came effect from the 1st of July 2017. The law will apply from the July 2017 and that it will apply here. So with this background, with this small background, the levy on the online gaming has been done. If I'm just giving a thought process here. Online levy, online levy of the online gaming, levy of the tax on the online gaming. But the bigger problem right now, what we will be facing, or that all online gaming company will face, recovery of tax. How the recovery of tax will be there, because the actual turnover will be not much then. Actual turnover will be much lesser. So the betting they have not covered as the turnover. For the purpose of trade, for their turnover, their commission was their turnover here. Someone has staked 1,000 rupees, and after that, he has some people has got 4,000 rupees. Four people are paying, but he has written only those his commission. So commission will be covered as his turnover for the purpose of accounting part here. They have not collected the tax on all the part here. So the tax amount which is right now saying is much higher than the actual turnover, 5,000, 5 times or 6 time right now. We have recently seen that in the case of the online gaming company, many of the online gaming company are into the ED radar. The ED has caught them and they are into the behind the bar due to this region or that region. The issue will be there how the assessment will take place because it was all the so-called notice, how the assessment will take place, whether the assessment will take place under section 73 or 74. I understand that it will definitely take place under section 73. If that is section 73, how the limitation has to be covered, because limitation, you will know that under section 73, there is some limitation has to be seen. If if the if the so-called notice is out of the GST, out of the limitation under section 73, then you can say that the operator has been saved. Otherwise, the operator will be in the soup. And very much important, all this operator has closed their business, nothing to do with this part. The partner has already left India. How the recovery will take place, God knows. So very big uncertainty that will come into this place here. However, let's see, as a student of law, we will try to capture, we will try to learn from this one. And let's see, is there any question? Then we will take up the question. Ayush, is there any question? Ayush,
Yes,
any
sir.
question that is there? And any question on the
Yes, sir.
spacecraft, on the game craft?
Yes, sir.
Mhm.
Sir, there is a question with the
Yeah, please.
total industry tax demand reportedly exceeding 1 lakh crore, apart from the total
Hmm.
revenue ever generated by this company.
Hmm.
Did the court address the reality that enforcing this demand will likely push the entire sector into bankruptcy, resulting in zero actual tax recovery?
I do not know what will happen here. It is a big question here, how they will recover the tax. Recovery of tax is the biggest problem right now. Nobody knows how much they will able to recover, how who will able to pay the taxes here, whether they are going to catch the director, whether they are going to catch the principal officer, how the recovery will take place. If this recovery does not take place, how this will play. In fact, my understanding is that this law, the SSA should argue for the purpose of prospective application. They have not argued for the purpose of prospective application. So the law is effective from 1st of July 2017. Right now, it's almost 9 years is going to be completed. After 9 years or after how much the money they will able to recover is very difficult right now. Unless there's something comes, say like something amnesty scheme comes, or like something overruling client, oh, they should have come for the purpose of uh, uh, dispense here, prospective overruling. I do not see how it will work, but naturally, it is a big problem for this online gaming company who have, and it is difficult for, as far as I'm concerned, it looks very difficult that the government will come for with some amnesty scheme, particularly with this type of company. Because in the GST regime, amnesty is something difficult because it is not only the union, but it is the state also. And again, it is the case where the online gaming is there. The moment the government will proceed for the purpose of amnesty, there will be a lot of hue and cry from all the political circles that the government is favoring the operator, gaming operator. So I do not know as of now what will happen, but yes, a difficult question. Definitely, this issue has to be covered. Yes, next one.
There is a question in the chat box, sir.
Yes, please.
If a player win a game and immediately reinvested those winning into a new gaming on the same platform, does the ruling imply GST must be levied against the new face value? How does this avoid the trap of compounding taxation?
Look, each staking is a different game. The moment you have staked twice or thrice, once you have won the game, and after that you have put an X, the moment you have tried to staking, the different actionable claim has been generated, created. In fact, it has been created. The moment it is a different actionable claim is created, is a supply here. So therefore, my understanding is that every time that you stake your money, every time an actionable claim is created, and every time it will be taxed at the rate of 28% on the full value.
Sir, there is another question.
Hmm.
Does this invoke IBC proceeding? or does it recovering shifting to personal liability too?
Look, IBC proceeding is not an easy proceeding. First of all, IBC proceeding can be filed in three ways. Under Section 7, where the financial creditor files the IBC proceeding. Under Section 9, where the corporate debtor itself files, and under Section 9, when the uh, operational creditor files, and under Section 10, when the corporate debtor itself can be filed. Whether the department who is going to receive the money, he is definitely a operational creditor. He can file, the department can file into the section under Section 9. But department, I think the department will never file. The moment department will file, the company will be very good here, will say that, okay, you liquidate it here. And once you have liquidated it, I have nothing to sell this property. You will be department will itself in loss. So department will never come for the purpose of Section 9 application. In the same time, when a corporate debtor try to file an application under Section 10 for the self-liquidation, it will also not allow, the department will come to the court, and therefore the department will not allow to this application to be maintainable. Also, most important point, the NCLT will also not allow, saying that NCLT will never allow any admission of any IBC proceedings or CIP proceeding against a company on which such a huge tax demand or tax demand is pending. The moment you file, that the NCLT will say that you are filing only to avoid the tax demand. So I do not think that IBC will be a good way for this purpose, or IBC or the department or the NCLT will allow the application under the IBC for these company who are into the liquidity, who are into this part here. So recovery will take place, but it is very much important how much take place, when take place, against whom it will take place. It's $1 million question. Whether department will able to take the money, because it is not a direct tax, it is an indirect tax. Right now, there is no one in the company where they can collect and they can pay the tax here. But let's see. It is just a speculation. Let's see what happens in the next couple of years. It will be definitely come into the public domain all this point here.
So
Next.
there is a question in chat box.
Hmm.
Why did the court dismiss the idea that players are simply betting against each other rather than transacting with the platform?
Yes. It is not a wagering agreement inter se between the player. There is no case of wagering agreement. They are not entering into the against the player. They are not claiming the money against the player. They are claiming the money against the operator here. So the court has this. So it is not a betting against each other. This is not the case that I am betting against you. Like take a case. In the case of online platform, nobody knows each other. There may be A does not know who is the person who is playing. B does not know. There is no prior contact with this type of player. There is no wagering agreement this type of player. How he will be able to know who is the playing, who is not playing? Only the computer will able to know. And you don't have the idea into this part here. So therefore, there cannot be any agreement against the player here. Whatever may be there, it can be against the um, operator there, nothing against the player. Each one player is not connected with the other players.
Sir, how will this shape Indian online gaming jurisprudence in the coming years?
Very badly, very badly. Now you will not see any of the gaming company coming forward for this type of activity unless the government does something here. So all this mobile game and everything like which is going on right now will be get finished here. There will be no gaming, online betting. Everything will be getting finished here. And the government is rightly doing this purpose here because these are creating a sin to the public health here. Many young people are addicted with this gambling here. They are, and for this purpose, the crimes are getting increased. You know that every people is right now dying for the smartphones. Every people, even though people are uh, they are just stealing the money. They are doing some crimes in order to purchase a smartphone. Everyone wants that a smartphone or a smartphone 10,000 rupees, 15,000 rupees, 20,000 rupees that comes here. People are stealing the money. People are entering into the crimes here to have some to have some smartphone. And once the smartphone is there, mostly people are watching the Facebook or LinkedIn or like this one social media. You know that many of the countries under the age of they have banned the social media for the person who are under the section who are under 18 or under 16, saying that their minors are not be allowed. Similarly, the online gamings will take place here. But in the online gamings, the people are getting addicted. They are sacrificing their hard-earned money for the purpose of some temptation, and therefore it is a social evil. So definitely that jurisprudence will be tough here. I do not see as of now that some people will come and like to pay 28% GST on this piece. Any question?
Thank you, sir. But till now, there is no question.
No issue here. Why did the court dismiss the idea of? I have received certain question here. If there are any questions, that will be there. No, so then we should say thank to everyone here.
Yes, sir. Thank you, sir.
This is of the this topic was a very important topic. I thought that uh, from our discussion it will be beneficial to all the people, particularly those who work onto the GST litigation, those who work into that uh, litigation side of their profession. So it will be helpful to all. We will definitely come forward with some new topic, particularly about the constitutional law and different law, and this type of webinar that will be a regular practice of the firm here. If someone has any question, then he can write to me directly here. I will send
Okay, sir.
I will just say that my email ID. I will send my email ID. Whoever wants to write, you can write very well to me. Thank you. Thanks.
Thank you,
Really
sir.
thanks to everyone. Thank you for participation and thank you for joining this part here. Thanks a lot.
Thank you, sir.
Mhm.